IPOs, M&A, regulatory affairs and risk management. Lastly, we have Mr. Umesh Sheikh from Pifelling Ming and Partner. With over 20 years of experience, he previously headed the Simon's Patent Department. He now consults industry clients on IP strategy after retiring in 2023. Over to you.
Good evening, everyone, and good evening, panel. So, as it is the last session, I would like to recommend everyone to please be aware of the challenges that we have, so this would be one of the interesting topic close to us because we are from the industry managing IP from various industries. So, as we all know, we have been hearing since yesterday that technology is growing at a very fast pace, right? We all agree on that, right? So even the research says 60% of the people agree that the technology is growing at a very fast pace, and then the regulations that governments are imposing are not controlling it anymore. So is there a way out of thinking onto how we can regulate this? At the same time, how industries because as we all know, each industry is different to each other, but when it comes to technologies that are coming up, they cut across all the industries. Because the industries might be by business, by needs, by business practices, and by the nature of work they do, and by the nature of products that they manufacture, they are different. But when it comes to technologies like AI, digitalization, or electrification, they cut across multiple segments. So with all this, the industries are also observing some challenges, but at the same time, they have to be competent in market, and coming to competent, when they are being competent, IP is one of the key where we all know that which can secure them the competitive advantage. But IP itself is also getting affected with these change in the rapid technologies that are coming up. So we have a panel here who has been expertise in those in their respective areas. As we have Ajendu from pharmaceutical, and then we have Anomi from Sri Lankan IP, and then we have Marcus and again from pharmaceutical, and then we have Uwe from Germany, and then we have yes, Devashish from again pharmaceutical. So it's fintech. So we, with all these varieties of industry backgrounds, we are all now. We don't say that we are touching upon all the challenges that industries are facing now, but what are the challenges that we have foreseen or we have come across as of now, and then how some of the opportunities that we have come up with to overcome those challenges is what we will be talking up today. So why don't
Hi. Good evening, everybody. I must thank GIPC for giving this opportunity for me to be a panelist in this forum. So I am a lawyer from Sri Lanka, so I propose discussing about the IP aspect and the protection and how it affects the industry due to certain challenges that the industry faces as a result of prosecution and enforcement delays. So Sri Lanka recognizes the importance of IP in supporting the economy. However, the IP policy is encouraging innovations and creativity. The law is in place, and the IP protection had been since 1800s. The first patent has been granted in Sri Lanka in 1860. And my firm is a firm founded in 1879. Since the inception of that, they have been filing trademark applications and patent applications. So the IP protection is in force, and right now the act that protects IP is the Intellectual Property Act of 2003, which protects trademarks, patents, industrial designs, copyright, and trade secrets. So trademarks, patents, and industrial designs can be registered. Copyright, there is protection, but there is no provision to register copyright. But Sri Lanka, being a party to the Berne Convention and the International Copyright Treaty, protection empowers under the treaties. So coming to the enforcement, the IP Act, we have a robust IP legal framework, but there are delays in prosecution as well as enforcement. So prosecution delays are at the NIPO because they don't have a proper digitalized system, and trademark registration sometimes takes over 10 years. It doesn't happen for all, but 10 years means the mark is due for renewal. So the industry is facing a challenge. They don't have a rightful mark at the end of it till 10 years, where they can't enforce their rights as a registered one. So same way the patents, we have problems with regard to certain industry-specific examiners. We lack those examiners, so then there are delays. Industrial designs, of course, are registered faster than that, and these delays have to be addressed, and there are certain measures taken which I will be discussing in the second round of the discussions. Enforcement also, there are delays in filing actions and the outcomes are delayed. One is due to the number of cases that are handled by courts. The civil actions are filed in Colombo, and the rest of it, the civil criminal actions are in respective jurisdictions. And there is awareness issues, delays. The enforcement authorities are not familiar, like the police. So these are challenges that are happening, and the remedies and other areas I will discuss in the second round. Thank you.
Why don't you?
Ladies and gentlemen, my name is Uwe Schrieg. I am with the German IP law firm Fenning, which is a medium-sized law firm in Germany, but filing a lot of EP applications, more than 1,000 a year. And it's one of the oldest IP law firms in Germany, and more than 150 years old. However, today I'm talking to you in my quality of an ex-Siemens patent head, having worked for Siemens for more than 35 years before I joined the law firm last year. So my experience is 20 years of being the head of one of the Siemens patent departments. And I was asked, what should industry focus on concerning IP? And as I asked myself, who am I to talk to so focused people and tell them what they should focus on? So I changed a little bit the topic and asked myself, what are the main challenges we face in IP? And I think all of us are aware of the main challenge, which is the budget. If you have enough budget, you can solve any problem. But we don't have as big budget as we would like to have. So what is the solution to that problem? The solution is twofold. That's what I know from my Siemens experience. You have to have a good strategy, prioritizing, and you have to have the right approach to quality. And I will talk about quality later in my second statement, but let me, in a nutshell, say what kind of strategy allows to cope with the low budget, and that is selecting, that's at least our Siemens approach, selecting between innovations that solve your own problems and selecting, and on the other side, selecting the innovations that make a difference for the customers. And in any account, the innovations that make a difference for the customers are much more valuable, because that is where you meet your competitors. Your competitors might not have the same problems as you have in the technical core, but they have the same tasks to satisfy the customer and make a difference or offer a difference to the customer. And so by this selection, you can considerably reduce your costs and And then the second point is the relation between quantity and quality, and I will talk about that later. Thank you.
Thanks for that. Devashish, why don't you?
Thank you, Shashi. I think very happy to be here, and thank you GIPC for inviting me and in front of this August panel. Now, so my points would be very specific actually, because I'm more of a generalist out of this kind of panel, because I head the legal and compliance of a fintech entity based out of Mumbai. So I look after the governance, the regulatory compliances and all everything, where IP is one of the aspects actually. So for me, the understanding about the IP in a fintech entity is like, it is something what we need to catch up with the innovation and technology, what is happening on day in and day out basis. Because technology, specifically in IT, fintech and all those startup sectors are really growing day by day. Technology. Now what we need to do, so basically most of our time when I sit with my senior management and the directors, we decide how to craft a right IP strategy to support the innovation and growth what our company or our organization is looking forward to. So that's first of the thing. I'll come more to it in the later part of my segment. So how to craft the right IP strategy. But considering the fact that all this explosion in innovation and technology is happening, we have to be mindful of the challenges what this particular sector is facing. So when I was kind of thinking about the challenges, what fintech as a whole, so when I talk about fintech, it's not only about payment, because I come from payment domain. There are insurance verticals, there are other wallets and all everything. So some of the key challenges, 8 to 9, what I talk about is basically the innovation and the growth of technology, and whether that technology is basically helping us or it is something which probably creating more problems for us in terms of delivering the right product or right solution to the customers. That's one. Secondly, we see the regulatory compliances as a whole, because as we see the technology and innovation is developing, we are yet to see that regulations and all are growing at that space. So that is something, one area which is a cause of concern for all of us. With the international laws, because see, India might having one set of law or other jurisdiction might have a different set of law. So for a legal professional or in-house counsel, it becomes extremely challenging to kind of maintain a balance between all the jurisdictions and all, because we work beyond India. We are into several jurisdictions also. Patentability, I think it's not limited patentability what I will be saying, because it's not necessarily all the innovation and technology is patentable. So I think patentability also becomes limited to a certain extent. So even if you are making any innovation and novelty and all, probably those things are not patentable at times. Open sourcing is another thing, because we do kind of, whenever you are producing and if you're doing something and it's open source software, you go for licensing and agreements and all, that's a challenge. So open sourcing is one challenge. Then we talk about all these latest legislations in terms of data privacy and all what we are seeing. Because data privacy which has come in India as a DPDP is extremely focused on certain specific areas, how you are using data, how you are kind of managing data, consent, notification and all. So at times it creates an embargo on developing the right IP approach also. AI, obviously, artificial intelligence, as we have seen all throughout those sessions, how it is kind of developing at the same time creating a challenge for IPR as a whole. Then there are a lot of disputes between a legacy entity like us and probably the startup entities in terms of a software they have developed, probably that is similar in nature, that's been copied and all. So that's a dispute what we always see. So these are some of the major challenges what I have seen as a professional in this particular sector. Obviously I'll talk more about the opportunities, because one of the themes is the opportunity and how to kind of craft a right strategy for a specific organization. So happy to hear more from others here.
Thanks, Devashish, for that. And I think, yes, you rightly touched upon on the open software as well as AI and these things. So with the new data regulation coming up, Marcus, why don't you speak about what are the challenges in AI in Europe? How's open source software and these things coming up as a challenge to the industries?
Actually, I'm not talking about data regulation, but
It's it's more on the industry-specific challenges that AI is posing.
Okay, so when thinking about the topic of today's session, industry-specific challenges, being one of our firm's pharma patent partners, I thought about talking to you about a little bit about patent strategies for AI-based drug discovery. And I'd like to share a little story with you. Let's go back in time 3-4 years, 2020, 2021. There were several strict lockdowns in Germany, as in many other countries, because of the COVID pandemic. And yeah, at the time we all didn't know what was happening, but interestingly, that time seemed to have been a very prolific time for our clients and inventors to come up with new inventions in the field of drugs and pharma. And I can tell you that, so I've got some statistics, so within a short period of time, like 4 months, I drafted and filed 30+ patent applications where a known drug was repurposed for the treatment of COVID. So a known drug that was already patented and everything, but was used for treating headaches, was all of a sudden used for treating COVID, according to the inventors. And I also drafted and filed about 20 patent applications which were actually directed at new drugs. Interestingly, more than 90% of these patent applications were based on purely AI-generated data. So all the inventors, they had to stay at home, it was lockdown, but they came up with these sort of fancy new ideas because they used some AI system in order to make their invention. So these were in silico data, there were no wet data. And of course, these AI data showed beautifully how good these respective drugs were at treating COVID. So, and me as a drafting and prosecuting patent attorney, of course I had to deal with the situation. I, being a partner of the firm, was allowed to go out and go to my office and work in the office. So I worked on these applications. Formally, it was not a problem for me. I mean, for those of you who are familiar in the pharma patent field, I mean, you would formulate second medical use claims, which are allowable in most jurisdictions, except for in India, I think you cannot patent those. And otherwise you would formulate product claims, methods of manufacturing, etc. However, these AI-based inventions, they also have to fulfill all the other usual patentability requirements. So novelty, inventive step, non-obviousness, sufficiency of disclosure, or enablement. And in these cases, novelty was not an issue because clearly these drugs were either new or at least the use was new. But with respect to the other two criteria, inventive step and sufficiency of disclosure, you always have to rely on a technical effect. And I think we have had this topic already in some sessions earlier. And so the applicant has to make it credible that the technical effect, which is the successful treatment of COVID, is actually achieved. Bear in mind, we only have AI data, so we don't really know whether the drug works. And in that context, being from a European perspective, I looked at first at the practice of the European Patent Office, and the European Patent Office has introduced this concept of plausibility. This is not a patentability requirement in the sense that it's codified in law, but it has been developed in terms of case law, and I'm coming to that in a minute. So in the scenario that I was faced with, the challenges that the pharma industry was faced with is 4 questions arose. Firstly, are there enough data and are they good enough? Do they have sufficient quality? And that sort of is an overlap with Mr. Schrieg, what he's probably going to say. Given that these are only AI data. Secondly, did the inventor, the applicant, have actually possession of the invention that he's claiming he has made? And once the applications have been filed, can we rely on further data that we generate after the filing, so post-published data? Are they useful to improve your position with respect to the patent office? And fourthly, in terms of patent strategy, me as a drafting patent attorney, when should we file the application? Should we file it as early as possible, at the risk of that a patent examiner says, I don't believe a word of what you've written there because you only have these theoretical data? Or should we file them later when we have generated some additional data at the risk that someone else has come up with the same idea or has actually published his invention? And so in this first round, I would just like to briefly tell you about the enlarged Board of Appeal decision, G2 out of 21, which has answered the third question about post-published data in the positive, saying that you cannot ignore post-published data merely because they are post-published. So in effect, that has been saying, the EPO in large board of appeal has been saying, yes, you can in principle consider these post-published data. And with respect to the other questions that I've just read to you, the EPO in large board of appeal has given a kind of, very wishy-washy answer if you ask me. They have said, and I read the head note to you, it has to be decided on a case-by-case basis. This is a very lawyer-like language. Whether the skilled person, based on common general knowledge and the disclosure of the application as filed, could derive this technical effect, relied upon as being encompassed by the teaching of the patent application. So if you ask me, and I've been presenting this beforehand when the EPO in large board of appeal president was sitting next to me, I think this is not a very good decision, and he did not like that. And with that, I would like to end the first round. In the second round, I would formulate some empirical rules.
Sure. Thanks Marcus for that. Ajendu, you want to add?
Yeah, so and I represent a pharma company and I'm a generic pharma. But in a pharma, there are basically two buckets. There's a brand side, there's a generic side, and both sides have a challenges. Like in terms of brand, a challenge is the IP laws are not harmonious across the globe. There are certain countries in which a patent is still not enforceable. Trademark is really not a good mark to enforce. So when you have spent so much money into your development, and again in a pharma field, having patents, having IP protection does not help you, because you are required to still secure a regulatory approval, which will take numerous years to get an approval. You have to do clinical trials, animal trials, show it is safe. There are many countries, including India, we do not allow patent linkage. So even if you have granted a patent for a molecule, and you get an approval 8 years down the line, your 8 years of patent term is gone, and there is no extensions which is offered. Apart from that, when we go to enforceability, again, every jurisdiction has a different way of enforcing the IP laws. And the most challenge, like Uwe said, is a budget. Like a brand, we usually say that they will have a good budget. But just imagine one product approved globally and they have to litigate everywhere. And it's one company, so their budget is going to get hampered. When we come to generic, again, the challenge is many countries, advanced or developed countries, allow multiple patent filing, which we call as a ticketing of a patent or evergreening. There are certain exclusivities granted to them, there are extensions granted to them. So then when you have to bring a generic into a market, you need to really go ahead and challenge them. And challenging a patent is not really something which is, it's first of all, it is not cheap, and second, it is not predictable. Like you may always feel that you have a good case, but at the end it is a judge, and in many or most of the countries, judges are not scientific people. They are lawyers who may have done BSc, some may be in BA, some may be in commerce, and they are going to decide on a technical matters. So sometimes that becomes really tricky.
Thanks for that. So you, why don't you, you have touched base on the cost as even Ajendu supported on that. So what should be the strategy of the companies and on when it comes to quality versus quantity, or when it comes to cost versus quantity?
So quantity versus quality is an important aspect of our work in order to cope with the budgets. And quality has two aspects. First one is the question, what at all is patent quality? And to be honest, I don't know. The only thing I can tell you is how you can find out what kind of quality you have to require. Because there are different aspects of quality. It depends basically on the purpose of the patent, of the single patent. So for example, if you are aiming at large cross-license agreements, then quality means for you velocity, getting a patent grant or getting patents granted as fast as possible, because you are collecting numbers of patents in order to be in a good position at a cross-license negotiation. If you are aiming at asserting your patents, enforcing your patents, then legal certainty and validity is your goal, and that requires a different approach to quality. And if you are aiming at licensing, it's highly probable that you will not litigate about the patent, but you need a wide scope of your patents. So you can see that these different goals, strategic goals, require different approaches to patent quality. And knowing in advance more or less what you want to do with your patents can considerably reduce the requirements on quality of your patents. So you can use that to lower costs. The second aspect of patent quality is that you have to have a look at patent quality along the value chain. And that means value chain starts with selecting the right inventions, the right innovations to protect. Then the patent attorney has to do a good draft, but then the patent offices have to do their job. And that's also, let's say, a hard requirement to have a good examination quality. And that is, to give you an example, the current discussion we have on a political level in Europe at the moment. Siemens, when I was still at Siemens, started a big project which ended up in a network of companies drafting or setting up a industry patent charter, patent quality charter, which I have drafted in the very beginning. And this charter requires that the subscribers aim not at big numbers and having a high rank in patent office statistics, but aiming at quality. And another requirement is to the patent offices to deliver a high quality examination. And in this regard, this network of companies is in a hard discussion with the European Patent Office, because we have observed, even if the patent office, the European Patent Office, delivers excellent quality, we observe that the quality is slightly decreasing. And if you follow the press, in 2024, the examiners of the EPO officially complained about their work pressure, and they say they cannot deliver or keep the high quality they're used to due to the rising workload and work pressure. So we entered into a discussion with the EPO about what kind of quality they should deliver, and this discussion is going on. But it's an interesting project, and every company is invited to subscribe to this industry patent quality charter. You can find that on the internet. It's an interesting project. Thank you.
Thanks, Ugo, for that. Anomi, with respect to NIPO, is it still the same challenge when it comes to quality, or when it comes to the other aspects? Is it overloaded, or how it is?
Yes, it is. Because NIPO looks at what is filed and what delays are there. So the specifications are looked at, and examinations, we lack the proper examiners, so there is an issue. Where the PCT filings are national phase, then it moves faster. So the start point is examiners. Yes.
So what are the other opportunities that you spoke when it comes to enforcement?
So when it comes to IP enforcement, even if trademarks are not registered, if the brands are used extensively, in Sri Lanka, we have this concept of unfair competition embodied in the statute. So unfair competition is defined in the Act as any act that is contrary to honest practice in the course of industrial or commercial activity, which causes confusion, damaging another's goodwill, or misleading the public, making false or unjustifiable allegations. That gives right for rightful owners to file action, and they can get interim relief from courts. So that is an opportunity.
Sure, thanks. So, Devashish, can you touch upon what are the opportunities that you, with respect to the strategy, and how the industry should frame their strategy when it comes to fintech kind of industries, or as you touch upon payment gateways or the others?
No, I think it's a very important question actually at this juncture, because see, irrespective of the challenges or the problems what we face, we have to find the opportunities. And that's where I think IPR is basically an enabler for an industry like us, where you can find the right opportunities. So I'll pick up 3-4 things. First and foremost, if you're innovating something, if you're developing something, and you're getting the right patent done, so obviously that leverages our brand, that leverages our scope of getting the right value, the market. That's a no-brainer. That's number one. Secondly, if I'm talking about your invest from the investment perspective, so just take the example of any startup entity who has the right product, got it patented and all, and they go for series funding and all. So obviously the investors are definitely going to take a completely different view towards them. So obviously the investment and all those things would be much at a premium than what they were expecting. Third thing is the brand recognition. Obviously that's no doubt about that. They are going to get a good brand recognition out of it. They have the right IPR strategy and the right IPR protection. And obviously the fourth thing is it adds to the bottom line. That's the revenue. The top line, the revenue. So obviously these are the 4 major kind of benefits what I see from getting the right IPR strategy done, means in terms of trademark or the patents or the brand protection, trade secrets, whatever it might be. So that is the first part of the thing. The second part of the thing is like, if I'm advising my organization to craft the right IP strategy, 3 things are extremely important for me. First and foremost, whether my IP strategy is aligning with my business strategy. Because if I have a business strategy which is not aligning with my IP strategy, then it's not going to work for anyone. So there are instances where I've seen that my MD comes to me for every little development and all, he says, then we should go for IPR filing and all. So we need to make them aware, like fine, so let's go to the value of it. That's most important. Second thing is, you have to decide, as the cost front we are talking about, I think some of the speakers are thinking. So it becomes very important whether we are thinking in-house or we are going outside. So my take on that is, if you are developing any technology and kind of creating a value, obviously in-house is extremely important because we in-house only developing the technology. But when it comes to say global regulations, challenges in legal and all, obviously we have to take the support of our outside counsel as and where it is required. So that's the second piece. And the third most important piece is it protection against disclosure? So am I protecting my patent or I'm disclosing it? So the classic case of trade secret versus patent, as we have all throughout discussed. So I think these are the key things in terms of my advice to my organization when we discuss it. These are the top 3 things in our mind. And at the end of the day, when you're navigating this entire IPR journey and all, we have to see the copyrights, trademarks, patents and all. For us, like a software patent or utility patent, it becomes extremely important that we need to see what kind of brand protection we are doing, how we are doing the licensing and all those kind of source codes. Source codes become extremely important for us. So how we are copywriting those source codes. And obviously the trade secrets if we have anything. So I'd say it's a holistic strategy, what I see. It takes care of the opportunities, the strategy, and at the end of the day, whether it is giving that mileage and that recognition to the organization. So that would be my take on that.
Thanks for that. So with rightly touched up by the Debashish, on the front of like collaboration licensing, when it comes to pharma, it will be too difficult, right? So how this strategy should be prepared for pharma industries?
Yeah, I don't think collaboration is difficult, but it just requires to be put into a right legal frame. We say India is a startup hub, right? And there are a lot of incubators. But is industry really exploiting them or checking out with them what startups are doing? And is there an opportunity to collaborate? Thereby you already get some start point for your own inventions. Like if you see typically when the small molecules were used to get invented for Pfizer or something, it was never a Pfizer R&D who would have done it. They usually get it in license from some universities in US and across the globe. In India we miss that. Partly because though at universities we filed the patent, when they come to us for in-licensing, we see they are filed mainly with the focus of having some publication. The focus is not really on trying to understand what should be disclosed, what should not be disclosed. Because every industry, whether you file a patent trademark, you want to keep certain thing as a industry secret, which could be a trade secret or it could be a general industry secret. Second is working with the governments, because there are governments schemes coming up, there are government collaborations coming up. Also, like in a regulatory framework, there are options like US FDA gives a grant on certain molecules like orphan drug or gain exclusivities. They also, in certain cases, announces special programs wherein they want to give away with the clinical trial requirements. Now, if you see in a topical space, it used to be all the clinical trials, and slowly now, if you see, they are moving into in vitro studies. So same way, so even they are aware that conducting a clinical trial, there could be ethical issues. There's also a cost issue and a time issue. So these are certain opportunities which need to look into. Also, there is an option of cross licensing, or kind of out licensing your invention. So, like say, you are developing some molecule which is in a phase 2, phase 3 into US, and you want to tap a territories in India, Europe. Do I really have to go and actually conduct trials there, or can I have some collaboration with the good pharma companies which are there, to whom I could out license my technology, my product, and they do all the activities. Now that way, I'm not just reducing the cost for me, but I'm also trying to have my drug, hitting the globe probably at a quicker time.
Thanks for that. So in the interest of time, Marcus, why don't you give the opportunities, and then we all can conclude.
So I'd like to pick up on what Uwe just said about quality, what quality of patents means. And being a drafting and prosecuting patent attorney, I focus it from a particular angle, namely you get a swift grant, so in the interest of your client, and hopefully it's a grant that is also subsequently valid in revocation proceedings. And going back to the sort of case study or example that I told you about earlier about these sort of repurposed drugs and new drugs for the treatment of COVID, I'd like to formulate 10 empirical rules as a drafting patent attorney with respect to how to deal with these AI data. And I would like to formulate the following rules. Firstly, bear in mind that the real test that a drug has to face in the real world is whether it works treating people. It's not whether it shows some good data in some large language model, network, whatever. If you rely on a specific technical effect in your application, and you almost certainly do in most cases, identify the effect in the application and actually provide data for it. Thirdly, do not speculate. You cannot fool the patent examiner. The EPO examiners, the USPTO examiners, and as I also learned, the Indian patent examiners, they're all experts in their field, and they do not believe you if you just speculate. Fourthly, if you have data that are AI generated, ask yourself honestly whether you believe them or not. And in many instances, you as an attorney, for example, would be told by your clients, these are wonderful data, but actually in many cases they're not worth the paper that they're written on. Fifthly, do not expect a patent examiner to be as convinced about your beautiful AI data as you are or as your client is. 6, be prepared to perform real experiments, and 7, be prepared to include them in the application before the application is filed. 8, consider also real wet experiments with respect to the US, and I'll come to that in a minute, to improve your position on inventorship, human inventorship. 9, consider different types of wet experiments, such as in vitro assays, binding assays, inhibition assays, cell culture data, animal model data, etc. 10, what I think where AI is really useful in our field is that you actually use the AI to generate comparative data to prove that your drug is better than other drugs. Because there, the examiner is much more inclined, from what I learned for the prosecution of these applications, they are much more inclined to believe you and believe the AI data that your drug that you have shown in additional wet experiments is also actually better than comparator drugs, as long as they only show this in AI-based data. Now, with respect to the US, I just would like to focus on one additional point. In the US, naming the correct inventor is very important, as many of you know, because this is for determining initial ownership of the application. And in the US, as in many other jurisdictions, as you probably know, only natural persons can be inventors. So, if you have applications where you only have AI data, there may be real problems for you with respect to the validity or enforceability of your US patent if you sort of stress the AI factor too much. So 8 empirical rules for the US. Firstly, maintain documentation of each human contribution to the invention. Secondly, consider AI as a tool to support broader claims. And thirdly, consider AI as a tool to also identify specific embodiments of your drug that you're looking at. Fourthly, do use real wet lab experiments. Fifth, include real description of real-life procedures for synthesizing your drug. Patenting AI, sixthly, patenting AI is probably not so important as long as you actually patent the resulting product. 7, improvements to AI may be patented, but that should be not your main focus. That's me talking as a pharma patent attorney. And 8thly, do not overstress AI inferences in the description. Because, why is that? Because the US examiner, as others, will use that statement. This was done purely using AI to show that your invention is actually obvious. And so be careful when you write, this was identified using AI. You have to introduce some human contribution to that. And with that, I would like to stop it. Thank you.
Thanks everyone. So that's the interesting discussion that we had. To summarize it, right from the start of patent quality versus quantity, as we all, as Uber rightly said, the industrial patent quality charter really helps, and then starting from there, as Devashish said, the strategy, not only IP strategy, we have to align our IP strategy with the business strategy, and which should lead to solving the realistic problems for the business and making you competitive enough in the industry. And coming to pharma, Ajendu and Marcus added more onto how those strategies were different for this thing, and at the same time the collaboration as well as licensing, and then how fast you can think, how fast you can make it filings, and no examiner is dumb enough to pick it up, whether it was created by AI or whether it is created by human. So it's always, we have to foresee those challenges and then sort it out at our end so that we can come up with a good competitive advantage filings. And nevertheless, with NIPO, we have also looked at the general challenges and the resolutions that Sri Lankan IPO is coming forward with. With that, I open up for 2 questions from anyone from audience, if you want. Everyone is tired. Sure. If no more questions, then we can wrap up the session for today.
Today. As we wrap up the technical sessions, may I invite our moderator to please felicitate our speakers. Starting with Mr. Ajendu. Ms. Anomi. Dr. Marcus. Mr. Devashish. Mr. Wood. With this, we mark the end of the technical sessions here. Thank you for being an amazing audience. Please join us in hall number 1 for the awards ceremony. Thank you.